Welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. We cover 4 fundamental questions in this class, and today we are talking about the third question, which is using property. There is so much to say about the right of public to access both public and private property that it's almost impossible to cover in any property class. But I think you need a short introduction to what we call public accommodations. And the reason is because public accommodation law is an important limitation on the ability of owners to exclude the public from their property. So it's a fairly narrow rule, a fairly narrow set of laws. And the first thing that you might need to understand is what a public accommodation actually is. And for that, we look to Section 2000A of the 1964 Civil Rights Act. It says a public accommodation includes a laundry list of items, but including things like hotels and motels, restaurants, gas stations selling food, movie theaters, stadiums, and similar types of places. Before the Civil War, we had general common law principles that required open access to these types of public accommodation. But after the Civil War, the Jim Crow laws came into play to allow or even require separate but equal facilities. The most discriminatory exclusion of racial and ethnic minorities, as you know, occurred well into the 20th century. This was despite the Civil Rights Act of 1866. That act only applied to race-based discrimination, and it only applied to public conduct. It was not interpreted to apply to private conduct. So fast forwarding to the 20th century, for the most part, it is no longer the case that the laws themselves by the 20th century had explicitly discriminatory terms within them, or that most private parties could blatantly discriminate. The 1964 Civil Rights Act prohibited certain kinds of discrimination, and protected categories in that act included race, color, a national origin, and religion. It was a fairly far-reaching piece of legislation which barred unequal application of the law in a variety of contexts. So you had Title I dealing with voter registration requirements, Title III stopping governments from barring access to public facilities, Title IV encouraging the desegregation of public schools, Title VI, which stopped discrimination by government agencies, including state and local governments that received federal funding, and Title VII, which prohibited employer discrimination. So our focus today, though, is property law all the time, and it is Title II, which is the public accommodation provisions. So why did they include public accommodation in this broader civil rights bill? Well, think about the time. So you had people doing sit-ins at lunch counters that were for white only. By the way, these are people who are still alive today. This is not so far into the past. So the Public Accommodations Title II of the Civil Rights Act was about the right to not eat at segregated counters. It was the right to not have to stay at segregated hotels. It was the right to eliminate the colored section of theaters. It seems really basic today, but there was so much of that kind of discrimination occurring that we had to enshrine it into federal law. So what does someone need to show a violation of the Civil Rights Act? So there are a few elements here worth mentioning. First, discrimination must have been committed. Second, the discrimination must have to have been on the basis of a protected category. Third, it must be related to accessing a place of public accommodation. So the discrimination has to relate to access. So carved out in these civil rights statute are a couple of things that might be of note. One is that the right to public accommodation did not apply to lodging establishments which had 5 or fewer rooms for rent and which are occupied by the proprietor as a home. So you were not forced under this law to occupy close quarters with people that you might not be able to tolerate if you're a small owner of, let's say, a bed and breakfast. Similarly, private clubs remain exempt from the Civil Rights Act. So if you have a membership club, you don't have to provide public accommodations, and you may discriminate on the bases that the Civil Rights Act would otherwise protect. So looking to the impact of the Civil Rights Act, of course, it made an impact on the way that policies were made in places of public accommodation. But we all know that discrimination goes beyond law. We all know that Black people in particular continue to be viewed with suspicion in retail stores and in restaurants. We know that they are treated differently, they and other people of color. You can't legislate for people's hearts. That is the work that we all have as attorneys and as people, going beyond the law to embed anti-discrimination principles, not just in the letter of the law and maybe the letter of policies, but also to help other people understand why the discrimination that we all too often see in places of public accommodation must change. So with that, I will leave it there. I look forward to engaging with you on Twitter, on my website, and I'd love to talk property, so look forward to hearing from you. Thanks again.